Hi, and welcome to the next installment of the 4-Minute Lawyer. I'm David Slonim of Slonim and Lemieux, and today we're going to be talking about life planning versus estate planning. One of the biggest issues that people have when they first talk to me is they say, well, I don't have much of an estate. Why do I need to do estate planning? And the reality is that most of the documents that we do when we have what's called estate planning is actually more life planning, what happens when you're actually alive versus what happens when you are not anymore. In fact, there's really only one document that is in place specifically for what happens to your stuff when you pass away, and that's, of course, your last will and testament. The other documents, including a trust, are going to be what is going to happen while you are alive, but maybe incapacitated. And the typical advance directives, which are specifically in place for when you are incapacitated or can't act on your own, are going to be the majority of the planning that we do when we do quote unquote estate planning. And again, I like to call it life planning because that's what we're really doing. We're planning for what's going to happen when you are alive, but potentially incapacitated or need somebody to act on your behalf. And what we have as far as those advanced directive documents primarily is going to be the durable power of attorney, which I have discussed in a previous episode. And that is going to cover what happens if you're unable to act for legal and financial matters. And that's going to be something that is not necessarily for incapacity, although it's preferred to use it that way, but you can actually use it in Florida even if you're not incapacitated. The other documents for your life planning are going to be your healthcare surrogate. That's going to be in place if something were to happen to you and somebody needs to make medical decisions on your behalf. A PreNeed Guardianship declaration is in place if there's something that needs to get done beyond a standard healthcare surrogate or power of attorney. That covers all of your life matters, so to speak, legal, financial, and medical. And also it goes beyond what a typical power of attorney does because, as I mentioned before, a power of attorney is really an extension of what you need to do. And sometimes somebody needs to act if there's going to be some exploitation, abuse, or neglect on you or your loved one, and so a guardianship may be necessary. And a PreNeed Guardianship declaration is going to tell the court what's going to happen, who you want to have in that place if there's a guardianship that's necessary. If you are at the end of your life and need to make determinations as to what's going to happen, if life support or not, then that's where the living will comes in. And the living will is not a do not resuscitate order. That is going to be something that is different, and that's going to be provided by your physician. So again, these four documents, the power of attorney, healthcare surrogate, PreNeed Guardianship declaration, and living will, are really important for your life planning. And only the last will, again, is in place in the event of when you pass away. And the trust agreement, if you have a need for that, is going to be both for while you're alive and also after you pass away. And that'll work in conjunction, typically, with your last will and testament. So all that together is what I call life planning, and recommend that that's for everybody, not necessarily just if you have an estate or not. That's it for the 4-Minute Lawyer. Subscribe if you like, and we will talk another time. Take care.